You?
I did my first arbitration case.
Tell us your name and where you're from.
I'm sorry. Again, I'm Scott Bernstein, California Employment Lawyers Association. My first arbitration case that actually went to a hearing was a case at the Pacific Stock Exchange on behalf of an 82-year-old widow whose stockbroker told her that she should be investing in a closed-end junk bond fund during the offering period. That was in 1992, and I've done a lot of arbitration cases since, some for employees, some for investors. I can tell you this. The combination of forced arbitration clauses, we can call it mandatory arbitration if you like to use 4 syllables where one will do. The meaning is the same. A forced arbitration clause combined with class waivers amounts to a private right of repeal of any law that the party in a position to force that agreement on people wants to repeal. It's that simple. The reality is that workers, this whole business about, workers should like arbitration. Well, they're not going to pursue it. The vast majority of them are the meek who are waiting to inherit the earth. The last thing they want to do is bring a claim against an employer, an existing employer or a former employer. They're scared all the time. It's a very unbalanced universe that they live in. So they're not going to make a claim individually. There's that one occasional, Norma Ray out there who will stand up for a bunch of other workers when the law is being violated. And without them, these laws simply would not be enforced. Arbitration itself, we're hearing how great it is. We keep hearing the proponents always say how great it is. If a food is really good and is good for you, you don't have to strap people into a chair and force feed it to them with a cake decorator. People don't voluntarily choose arbitration after the fact. They get forced into it. It's really that simple. Now, is there an exception to that? Sure. Business against business when they're on equal footing. If General Railway Signal and TRW want to square off and they decide, well, let's get this arbitrator who understands the industry better than the judges do, fine. That's the classic reason for arbitration. That's why the Federal Arbitration Act was passed in 1925. It was businesses on equal footing against businesses on equal footing, not Italian Colors Restaurant versus American Express. That's not what it was intended for. This isn't a bill that, ultimately, this is a bill that's for workers, but the problem of forced arbitration is not one where workers are the only victims. So are consumers, so are small businesses. In a major way, so are small businesses. So there's, it's a far from level playing field. Can you strike and rank arbitrators? Yes, but who's in the pool? You get a list of 10 arbitrators, and they're all former defense attorneys. You're going to strike and rank until there's one left standing. What good have you done for yourself? The arbitration forums, I've heard the argument that, you don't hire a specific arbitrator, you hire the forum. So what? It's still, there's massive repeat player bias. The arbitrators outside of FINRA, the arbitrators are actually charging something more akin to a legal hourly billing rate. They want that work. So who are they going to upset? If they upset the worker, if they do something unfair to an individual worker in arbitration, what does it matter? That worker's never going to be in another arbitration in his or her life. Mm-hmm. But the company that chose that forum, the company that drafted the arbitration clause, and I hate to call it agreement because agreement has become a bit of a homonym. There are things that are really mutually agreed to, and there are things that you accept because if you want to eat, you're going to click the box. So why even bother to read it if you don't have a choice? And even if you do read it, you're not going to understand it. So, you get into these very one-sided forum situations where if something bad happens at JAMS, that large company can change its arbitration clause right afterward and decide to start using AAA. Or vice versa, or some other outfit like the National Arbitration Forum, which ultimately was shut down by the Minnesota Attorney General. It's corrupt. It's corrupt. Here's the thing. You can go to one extreme and you look at Article 3 judges. The people who founded this country understood that people resolving disputes have to be independent, and they created an independent judiciary. Do we have some judges who we'd rather not have on the bench? Yeah, that's the price we pay. It's an insurance policy to have an independent third branch. I've for years been calling arbitrators Article -3 judges. because they respond to the repeat players. They have to if they want to keep working.
Thank you.
So I think, yes, I think there is an inherent conflict of interest. And I know a number of these judges who are people of the utmost integrity, but there is that compunction when you know that Company X has used your services many times. If you find too many times for the other side, Company X isn't going to come to you. And I know there are some judges who will, ignore that economic reality and do what they think is the right thing. But again, this system, it seems to me, is so inherently unfair and weighted against the employee that I just think that this is a really important measure. I just think in today's world you cannot really, with a straight face, say that it is a mutual and freely consented agreement when someone's looking for a job and they get offered the job, and here's you either sign this or you're going to get fired. You won't get the job. That's just not an equal playing field. And it's my hope that we will stop seeing these incredibly disparate kinds of agreements that take the hard work that we've done up here to protect working people, and to be able to sign away your rights in order to get a job really, I think, undermines the work that we have done here. And so I'm going to move the bill, and I thank you for doing this. Again, I think there has to be a level playing field. I don't think either side should be given an advantage. It has to be level. And clearly in today's world, this is not a level playing field. So I thank you for bringing the bill, and I'm going to move the bill.
Been moved. Any other comments?
Yeah.
Vice Chair Stone?
Thank you, Mr. Chairman.
And you're going to agree with me. I know, Senator Stone.
But probably not this time, but I do respect your comments, and but I do have some grave concerns. We still have high unemployment numbers. People are very happy to get a job. And by the way, if it's okay with the chair, I'd like Jennifer Barrera to come up and at least respond to some of the issues that this esteemed attorney had mentioned. But let me just say that as a small businessman, arbitration is very attractive to employers, especially in the state of California. The American Tort Reform Association Judicial Hellholes Watch List for 2014-15 found California was ranked as having the second worst litigation environment in the country. And this is why I believe that the Cal Chamber has called this yet another job killer bill, which we seem to hear an awful lot on this dais. And I'm also hearing that it should be the state's responsibility that people, when they're filling out all their employment forms, that they are going to be compelled to read it in front of the employer, and they're going to be compelled to understand it in front of the employer. These people are just happy to get jobs. And, you sign a car, you sign paperwork this big, you buy a house today because of many of the actions of this body, you have to sign papers this thick. And we wonder why we can't be job nurturers in the state of California. My concern is that the restrictions on the waivers of this bill are preempted by federal law. It directly conflicts with the rulings both of the California Supreme Court and the U.S. Supreme Court. And as was well articulated, the bill is unnecessary as there are already adequate protections for mandatory pre-dispute employee arbitration agreements. And the Anandari case that was so well articulated by memory with no notes, which I'm very impressed also by your abilities, provides for a neutral arbitrator that gets vetted by both sides. They both can say no. They can pick an arbitrator they think is going to be fair. You get just as much, I think, an opportunity to get a fair arbitrator as you will ultimately getting a fair judge. The difference is that you're going to get that arbitrator a lot sooner rather than later, because when you get into our congested court system, our employees are going to wait months, maybe in some cases a year or more before they get the compensation that may be due. And certainly the heinous case of the gentleman not receiving his paycheck after months certainly has a legal issue which he will certainly prevail in a court of law. Adequate opportunity to conduct discovery, written arbitration award, and judicial review of the award, and no requirement for the employee to pay unreasonable costs that they would not incur in legal arbitration. And arbitration agreements that have not included these mandatory provisions have been regularly struck down as unconscionable. And empirical data suggests that arbitration provides an effective and efficient means to resolve employee-related claims, especially for low-wage earners. So I'll go ahead and let you now respond to what this esteemed attorney had to say, but I have grave concerns about this bill.
Thank you, Senator Stone. You know, just to go, I guess at the basic level disagree that it's an unfair forum based upon the studies that we have seen in actual practice. I can tell you that although I haven't practiced, I'm a recovering attorney as well, and haven't practiced employment law for several years now. For a lot of our company members, there was a question as to whether or not to even continue to include arbitration agreements, because there are so many often occasions when employers actually do not prevail in an arbitration. You have situations in arbitration, actually, because it is a forum in which you have a more informal setting, that the arbitrator will not grant dispositive motions for claims such as a summary judgment, which you can bring in arbitration. They are more reluctant to grant those because they want to make sure that the employees have their voice heard, that they have the opportunity to present evidence, that they have an opportunity to present their case. And so from employers' perspective, there was a question as to whether or not to continue arbitration and rather go to a court where there was more opportunity to have these dispositive motions granted when there was an invalid or a claim that lacked merit. So then there becomes the perspective, then I assume, that people will say, well, then why do employers want to utilize arbitration agreements if they're not successful? At the end of the day, it's not whether or not they're successful in the underlying claim. If an employee has had an issue with regards to their rights being violated, if there's compensation due, then the employee should pay, no question about it, regardless of if it's in arbitration or if it's in a court of law. But what arbitration does for an employer is control the litigation costs with regards to attorney's fees, with regards to court cases. Our judicial budget has been reduced over the last few years, as the legislators obviously know. And civil cases are the ones that are taking the hit. So you have civil trials now being set 3 to 5 years out from the date that complaint is filed. And in employment cases, the majority of employment claims require the employer to pay not only their attorney's fees, but the plaintiff's attorney's fees as well. That is a huge cost to the employer, regardless of what the underlying award is. It's a huge unknown risk for years going on until you can actually get to trial and have that issue determined. And so arbitration is a way in which to control the litigation costs, not necessarily with regards to whether or not they win on the underlying claim. So that's one of the reasons that employers require and want to utilize these mandatory arbitration agreements. With regards to the arbitrators themselves, again, we dispute the repeat player issue because the law forces us to pay the arbitration fees. That's why we pay them. And I think it's an unfair allegation to say that because we pay them now that we've created some repeat player favoritism. It's just not the case. An arbitrator, like I said before in prior practices, has no interest and has ethical duties that they are required to remain impartial. And if at any time they believe they cannot be impartial, they have an ethical obligation by law to recuse themselves from the arbitration. So I don't know if there's any other particular question, but if you have any, I'm happy to answer.
Thank you. Thank you. And any other senators want to comment? Senator Deno?
Please let Mr. Broad speak, and
Yeah.
I'm happy to follow.
In the employment context, you have to deal with realities. And you're talking about a situation, everybody knows that on the first day somebody comes to a job, they'll sign anything. Anything that's put in front of them. Everybody knows that. Arbitration started out, as Mr. Bernstein pointed out, as the author pointed out, everybody's pointed out, as a relationship between equals. And that includes employers and unions, businesses and other businesses. An individual worker who doesn't even know what arbitration is asked to sign some form that they can't possibly understand with a theoretical right to negotiate that doesn't exist at all in any way, shape, or form. It's entirely shaped by the employer. What we've done in this legislature since about 1918 is develop laws to try to give workers an equal chance. And that's why employers like this, because it takes away that chance. And they know that, and we know that, and everybody knows that, and we might as well just admit it. And because that's what it's about.
Right. Thank you. So then you want to, Senator Deno, go ahead.
Fascinating debate. We're looking at a level playing field right here. folks who know the law well and can articulate it better than any of us up here. And as a spectator, I'm enjoying it quite a bit. But as an employer for the past 37 years, I have never once thought of forcing such an agreement upon someone as a condition of employment. It just wouldn't feel right. And I don't want to suggest that there's no benefit to arbitration. We've already heard many examples of why and when arbitration can be beneficial and a better option when the parties are on equal footing. But given that that's just not the case at the time of employment, why wouldn't we want to allow the aggrieved party to have some options if something goes wrong? And these forms are there to take away an option. So I again, appreciate the debate, strong points made on both sides, but I know where I land, and Assemblyman, I'd be happy to join you as a co-author when you are amending the bill.
I would be honored. Thank you.
Thank you.
Thank you.
And I move the bill.
Yeah, I think it's been moved
I
already.
think
It's been moved,
Senator
and
Jackson beat me
and
to
don't
that.
don't worry, you'll have an opportunity in judiciary to discuss it again. Yeah, it's still be part 2 of this. Any more comments? Any more suggestions? We have been properly moved, and I think Senator Hernandez, would you like to close?
Thank you, Mr. Chair. I really appreciate the robust discussion. There was a lot to be said on both sides, but I think ultimately, as California lawmakers, our goal is to enhance the quality of life for the people of California, particularly the hardworking folks that find themselves as underserved and underrepresented. And case in point, just to make a quick side note, I have a Pizza Hut application right here where one is able to apply for a job, give their personal information, apply and articulate what position they'd like. And at the back of the agreement, it says, or the application, there's an agreement, and it says you must sign here. And nowhere does it disclose on this application that it's voluntary, that it should not be a condition for employment, that you don't have to sign it. It says this is where you sign the bottom line when you fill out your application. There is no notice to the potential employee applicant that that section is not necessary to be signed. So there is a lot of misleading information when it comes to accessing employment, and it isn't a level playing field. So I appreciate those words in support, and I appreciate, again, everything that was said. I strongly ask for an aye vote here today.
You almost lost it. Madam Chair, Madam Secretary, please call a roll before our members leave.
The motion is due pass to judiciary. Mendoza?
Aye.
Mendoza, aye. Stone? No. Stone, no. Jackson? Aye. Jackson, aye. Leno?
Aye.
Leno, aye. Mitchell? Aye. Mitchell, aye.
Congratulations, your bill is out.
Thank you very much.
Well, thank you. You have one more, right, Mr. You're here?
Yes, sir, Mr. Chair.
Okay, yes. Go ahead and proceed with AB 1509, is it?
Thank you, Mr. Chair and members. Assembly Bill 1509 will strengthen California's critical employment retaliation provisions in 2 important ways. Recent cases examples highlight several major gaps in existing California statutes that prohibit retaliation against employees for engaging in protected activity. AB 1509 will close those gaps in order to protect California workers. First, AB 1509 will provide that an employer shall not retaliate against an employee because the employee is a family member of another worker who has engaged in protected activity. Second, this bill will provide that existing prohibitions against retaliation apply to a client employer or a controlling employer. Recent amendments reflect language which has been agreed to between the California Labor Federation and the California Chamber of Commerce. I do respectfully ask for your aye vote.
Great. Any witnesses in support?
Mr. Chair and members, Caitlin Vega for the California Labor Federation. We are the sponsors of this measure. All this measure does is look at the existing bodies of law where an employer, a client employer would already be liable either for health and safety violations or for wage and hour violations, and extends the law of retaliation to say if you were liable for the existing violation, you should also be a party that could be held liable if you retaliate against that worker because they reported the violation. Super important protection for workers in the subcontracted economy, and it's a bill that we've been able to negotiate with the other side on. Thank you.
Thank you. Okay, witnesses, more witnesses support?
Randy Cheek with SEIU Local 1000 and strong support.
thank you. Any witnesses in opposition? Seeing none, and been properly moved. Any comments from other senators? Seeing none, Madam Secretary, please call the roll.
The motion is due pass to judiciary. Mendoza?
Aye.
Mendoza, aye. Stone? Stone, no. Jackson? Leno?
Aye.
Leno, aye. Mitchell?
We're gonna leave the roll open for the other members to come in now.
Thank you, Mr. Chair, and if I may, I just want to thank Senator Leno for doing such a fine job in the conference committee over the last several weeks. Thank you.
There you go. Thank you. All right, Senator Gonzalez.
It's great. We'll never present this bill in front of a female legislator. Good morning.
How you doing?
I assume I'm next.
You're our
Okay.
next. Yes.
It's okay, I forgive you. Good morning, Mr. Chair. I was noting that I've never been able to present this bill in front of a female legislator, and I apparently will not today. It is a sad note on our institution. Good morning, Chair and Senators. No doubt you've all heard the stories about the NFL's problems with respect to women. This includes the longstanding tradition of treating their cheerleaders as glorified volunteers, independent contractors, or simply refusing to abide by basic wage and hour laws. AB 202 would simply clarify what we believe to already be existing California law and ensure that professional cheerleaders and dancers are treated as employees protected by all employment law, including at least a minimum wage for required practice time, performance, and any other ambassador or modeling duties, including wait time, unless the local law calls for a living wage, in which case, of course, that's what they should be earning. Payment for overtime, paid sick leave, and workers' compensation in the event of an injury. Specifically, this bill will also hold that professional sports teams accountable for the employment practices of their chosen contractor, subject to last year's AB 1897 authored by Assemblymember Hernandez, whether or not that work was performed in the stadium or at an outside event. AB 202 simply demands that our professional sports teams or their chosen contractor treat the women on the field with the same dignity and respect as we treat the guys selling us the beer. We have witnesses that will testify, starting with Lisa Murray, a former Golden State Warriors dancer.
Good morning, Senators. My name is Lisa Murray, and I am a former Golden State Warriors cheerleader. Go Warriors. I worked for 9 to 10 months out of the year, and sometimes worked 30 to 40 hours a week if it was the peak of the season. My menial pay was $10 an hour for my first 2 years, $14 an hour for my third year, and $20 if I made captain. When cheerleading started in the NFL, it was a volunteer position, and a women's role in the workplace was very different from their role today. Football players and staff weren't paid either. In the 1970s, television helped turn it into a big business. And at that same time, NFL turned cheerleading into a professional sideline entertainment, starting with the Dallas Cowboy cheerleaders. Unlike the players and staff, most professional cheerleaders have not seen an increase in pay for years and for some decades. We have seen these franchises explode, along with the rights and compensation for most employees, except for the cheerleaders. It's about time we recognize that the added value we provide far outweighs our compensation. Many cheerleaders are forced to be 1099 employees, which allows the organization to abuse the system and withhold traditional rights that are provided to salary and hourly employees. Some go as far as claiming us as seasonal employees, which allow us to pay below minimum wage despite working 9 to 10 months out of the year. The NFL and NBA use tactics such as threatening to withhold pay and even termination in an effort to keep women from speaking up about the injustice that is happening behind closed doors. A team such as the Dallas Mavericks make it mandatory to attend unpaid practices and appearances. In my tenure with the Warriors, I was trained on how to answer questions regarding pay with false information. According to the documentation I was given, I was advised to respond with, and I quote, "All dance teams get paid. This is a hobby, and I hold a full-time job on the side." These organizations have not treated us as valuable employees, even though we have proven this to be a profitable venture. More importantly, cheerleaders are an added value to these sports enterprises. Teams have a long history of cheating their athletes and employees out of being paid fairly. In the NBA, players were underpaid by owners for many years until they formed a union in 1954, and even then, it took them 10 years to recognize the National Basketball Players Association. And prior to the National Basketball Players Association, the players received no minimum wage, no pensions, no per diem, and we're paid an average salary of about $8,000. Teams continue to spend too much money on unproven players and yet continue to cheat cheerleaders out of a living wage. Every woman has had to fight for her rights in the workplace and fair working conditions. This profession has been overlooked. Regardless of your personal opinion, we are talking about fairness in the workplace and helping women, who in 2013 still made 78 cents for every dollar earned by men. Help make it fair for women in this profession to be compensated fairly. Your job today is not to determine what a fair wage would be, but to make sure that these franchises are not exempt from abiding by the law and how they treat their employees. Thank you.
Mr. Chair and members, Caitlin Vega for the California Labor Federation, also here in support. The idea of an independent contractor is that it's supposed to be a worker delivering providing a service or providing a product or labor free from the control of the employer. I think when you think about these cheerleaders, the idea that they are completely free from control, can just do things the way they want to do them, it's pretty clear that that's not the way that it actually works. Every single aspect to their performance, to their appearance, to everything that goes on is clearly tightly controlled by the employer. And so the idea that these are just independent business operators that the employer owes no obligation to is clearly false. We're here in strong support of this bill. Thank you.
Mr. Chairman and members, Barry Broad on behalf of the Teamsters, the SAG-AFTRA, the Screen Actors Guild, and the Jockeys Guild, which all of whom have an interest in this area in sports and in performance. And in every single occupation that involves performance of any sort, there tends to be high demand for the job and the notion that it's a privilege to have the job and that therefore you need to make a sacrifice of basic standards just to get and keep the job. And there is probably no position more carefully controlled in terms of on-the-job conduct and off-the-job conduct than professional cheerleaders. And I would commend you to, the NPR did an amazing report about this, in which the amount of control, it was so overwhelming, like who you could date, what you could dress, wear, how you would behave on and off the job 24/7 at any time. I've actually never seen anything like it. So these workers just need the same protections everybody else has. And it's tempting, because when I first looked at this bill, it's like cheerleaders. You know, I had this response like, oh, cheerleaders. And I thought, I'm having that response? Me, a guy who spent his entire life thinking about workers, that's a confession. But I had that response. Oh, it's cheerleaders. And I thought, oh my God, Barry, what is wrong with you? And the fact of the matter is that's how society responds. But it's wrong. These are workers. They deserve the same rights as everybody else, and they work really hard, and they make plenty of money for these franchises. Virgin I vote.
Thank you. Any other witnesses support? Any witnesses in opposition? Dare come forward. Okay, there's none, of course. Any comments from our senators? Vice Chair Stone?
Yeah, thank you, Mr. Chairman. Thank you for your testimony. You know, we're dealing with franchises, and they have specific rules and regulations that they implement to add value to their franchises. I think that this bill is in response to a lawsuit by the Reltns. And they lost a lawsuit. And so the existing remedies already exist in law. You just have to file them. I just have strong concerns about the state intervening in private contractual relationships. That's something I don't think we should do. If you want to unionize, unionize, you know, and you know, selectively picking California franchises, you know, when we have nationwide franchises to compete with, I think puts us on, again, another unequal playing field. So I think existing remedies exist in law. I appreciate that the Reltns took advantage of that. I think they got $8 million for, what, 120 players? So what's something like that? It was,
Yeah, I'll let you finish.
okay. Yeah, it's a lawsuit. I think they got a significant award.
It was $1.25 million.
Oh, $1.25 million for.
It wasn't an award, though. The lawsuit was settled by the Raiders because they clearly knew that they were
wrong.
However, each team deals with it separately, and what we had hoped would happen after that admission by the Raiders that they were doing it wrong is that the other teams would follow suit. It just hasn't happened. And as a result of these very secretive contracts that these women have to sign, and I heard the whole arbitration issue. This is very similar. They're made to believe that they, in fact, will be sued if they bring this forward, that they will be liable, held liable, obviously lose their job. They will lose their status. They're young women trying to often make a career out of something, and that they will actually be sued by the team if they bring up their basic rights. So I understand that it feels like there should be a remedy in law, and there should be, but our law should be very clear. There's still those teams nationwide, and we're not the only state dealing with this. Last week, an assemblywoman in New York brought the same legislation forward because these lawsuits are going on throughout the nation. So it'd be great, but I don't think we want to sit around and make all these women sue, quite frankly, to get their basic provisions and to be very clear. We want to clarify the law so that both the team and some of these teams say it's not our problem, we hired a contractor. Well, the contractor still says on the San Diego Chargers website, we pay $75 a game. That's what a cheerleader gets. No pay for practices, no pay for wait time, no pay for modeling, no pay for ambassador duties that they're required. That is against the law. But when these women have signed contracts that they believe keeps them from even speaking out against it. I mean, we have had very private conversations with women who are scared to death to come forward with this, and we've had a litany of former Raiderettes and one Golden State Warrior who's been willing to come forward, but it is a very scary proposition, and we want to make sure that the law is clear.
Well, I appreciate those comments. Let me just say that, and I'm not a lawyer, but I know there's a significant legal test for what an independent contractor is and what an independent contractor isn't. And I think there are existing remedies. Again, I don't believe we should get involved in private contractual relationships of any industry, whether it's cheerleading or anything else. That's between an employer and independent contractor or an employee. You certainly have the right to unionize if you feel that, collectively you're...
Well, actually, independent contractors don't have the right to unionize. In order for them to unionize, they first have to be made employees, and so that is one of the issues here. They have no collective action available to them.
Good point. Thank you for making that clarification.
Thank you, Senator Stone. Any other comments?
Thank you, Mr. Chair. The issue is egregious on its face. And unfortunately, our state law is very ambiguous and indecisive as to who is an independent contractor and who is an employee. Courts may rule as they may rule, but it's our job as legislators to make our statement. And that's what your bill does. Please add me as a co-author.
Thank you.
I have a question for you. How is it, or let me rephrase, can a professional sports team legally discriminate in this employment area on the basis of gender?
That's a good question, and one which I assume I'd have to get back on that one.
Because certainly at the collegiate level, we see cheerleaders, both male and female.
And I think there is one professional team that actually has male cheerleaders as well, but on the most, part, they are female. But I think, I don't know if there's somebody here. There's some other case law. I believe it came up under a lawsuit against Hooters. Quite frankly, that might be deciding on this, but I'd have to go find out.
Just curious. Please.
Senator, my understanding is that because there is no employment status, there's no protection against employment discrimination. And so that's part of why employment status is so important. If you don't have employment status, none of the rights or remedies that are available to protect workers are going to apply.
All the more reason.
Absolutely. Although I don't want to say, that I think that there are provisions for entertainers when they're looking for females versus males and different things, and I'm not sure. I think that obviously if they're asking for females, there might be, in the future, as we're seeing a lot of these come forward, some issues with transgender rights and some other things that will never be clarified if they're not employees.
So please add me as a co-author.
Thank you, sir.
I move the bill. And have you considered making this a sport?
I got a bill for that.
Right.
Thank you. I would also like to be added, actually. No, I appreciate you bringing this bill forward. Would you like to close?
I just respectfully ask for an aye vote, and one day hope that a female legislator will ever sit through one of these hearings. Two committee hearings in the Assembly and one in the Senate. I was grateful that at least there were females on the committee, but it says something about our legislature. As long as I have a chance to say that, you know, I could take it through 2 committees in the Assembly, and not a single woman sat on either of those. So that's it. That's my close. I respectfully ask for an aye vote.
Great, thank you. Hopefully they'll come back and add on a few minutes. So with that, Madam Secretary, please call the roll.
The motion is due pass to appropriations. Mendoza?
Aye.
Mendoza, aye. Stone?
No.
Stone, no. Jackson? Leno? Aye. Leno, aye. Mitchell?
We'll hold the roll open for your bill. Add on people as the other senators as they come in. Thank you.